13 is about waters of the United States. And the way things are now, despite 2 Supreme Court rulings otherwise, is the Army Corps of Engineers in conjunction with the EPA can show up on any piece of farm ground or property here in the state of Idaho. They can dig a pit on your property, they can find subsurface moisture in the ground, and then they can connect that with some water body 10, in our case, 15 miles away. And then they can declare that ground as waters of the United States. And I consider it a form of theft. Maybe the attorneys would say I'm not allowed to say that, but whatever. And this is a growing issue. And so right now you have Army Corps of Engineers declaring stock water ponds, irrigation ditches, waters of the United States. And that just kills Idaho's economy. And so this is an issue we need more and more people to talk about, to get involved in. And we got the best in the business to come educate us today. And so it's an exciting lineup because we have the Sackett family, both Mike and Chantell Sackett. And so far, when I've called them friends, they haven't said no. So I'm going to say my friends, the Sackett. They fought for 20 years on this issue. They're the only individuals in U.S. history to go to the Supreme Court and win twice. And I'm not going to tell their story for them, but they fought for everybody in this state, and most people don't know that. And I think it's a real shame. So I'm glad that some folks are tuning in via the live stream and came in to hear about that. So with that, I would like to introduce the Sackett. So please come on up, Mike, Chantell. Thank you guys.
Hi, thank you for having us. I'm Chantell Sackett, my husband Mike, and we just appreciate Heather taking up this cause, taking this up, and we just want you to understand when you have a piece of property and you buy it and you want to build a home on it and you do everything right to get the permits, and then you have somebody from an agency show up just a couple days after you start preparing it and say, no, we think you're building in a wetland. And then they say, not only that, we want you to restore the property, and if you don't, we're gonna fine you $23,500 a day. And so it lit a fire under Mike and I. And we said, this isn't right, and we went and spoke to our local District 1A representative, and he was also at a loss. So I'm going to turn this over to my husband and just let him follow up with the rest of the story.
Hi. So I always got to tell a little bit more of the story. My wife is, if you look up the word frugal in the dictionary, her picture's there. And I left on a snowmobile trip, and when I came back, I walked in the house and she says, I gotta tell you something. And I'm thinking, oh, what's this about? Well, she bought a piece of property, and we knew the person that owned it. So anyway, we went down and looked at it. It's like, yeah, it's great. It's got a cool view of Priest Lake. That's where we live. And so my wife does very good on dotting I's and crossing T's, went and got all of our permits. We put the culvert in, we started building the site, and literally it was ready. The next day, the guy, we already had the guy under contract to put the foundation in. So anyway, as she said, they showed up, and it got, I won't tell you about the heated conversation that my wife had with somebody from the EPA, but when we went to our construction attorney in Priest River, he said to us, he says, this is not anything I know anything about, but I know a guy in Spokane. His name's Les Weatherhead. You need to go see him. Well, when I first moved to Priest Lake, I went up there and opened up the Yamaha dealership. Well, it just happened to be that I actually sold the guy some toys. So when we walked in his office, downtown Spokane, he walks in, and he is a very colorful guy with his wording, I'll say it that way. But he came in there and he said, listen, if I was an attorney right out of college, I'd be standing on this table and I would be telling you to borrow, steal, beg every bit of money you can get, because this thing's winnable. He goes, but, and our construction company at the time was pretty lucrative, and I said, well, I'm ready to write a check, and we talked about money, and he says, you won't get up to the plate to even try to hit the wall. He goes, these guys are gonna bury you. It's like, well, that doesn't seem too fair. So we were headed out on vacation. We were gone a couple days later. He calls up and he said, I just can't get this case off my mind. This thing is so important. I have a friend that I did some business with by the name of Reed Hopper, and he's with the Pacific Legal Foundation. First question I have is, well, what's the Pacific Legal Foundation? Well, it was started under Reagan when he was governor of California. It's a nonprofit law firm, and they want to talk to you. It's like, well, that's pretty cool. So we actually get a phone call from Damian. This is Damian over here, and we start talking. And Damian's a good attorney, but he's, as most attorneys, they really don't, they're trying to protect you. And he wanted us just, let's get this thing settled with the EPA. Well, their settlement was, well, you guys put the property back the way it was. Plant wetlands plants that have never been in northern Idaho. And then, by the way, fence it and take care of it for eternity. Oh, that seems like a really good idea for you. So we said no, and went back and forth for a little while, and they issued a compliance order. The fines were $23,500. Anyway, so now Damian has become very involved in our life, and about that, not too long after Damian got involved, unfortunately, there was another piece of property at Priest Lake where a guy got into a criminal deal with the EPA, and the Kegels that you're gonna hear from in a minute, they actually walked in our office, and Ray came in, and they already knew a little bit about the case, and Ray knows, he's forgot more than the people at the court will ever know. That's what I'm gonna say. And he just like, this is wrong, blah, blah, blah. So they did a delineation on our property, no wetlands. Well, now we go through the court system in Boise. Judge Hodges says, no, you can't sue the government. Because that's really what we wanted to do, is we were suing for a day in court because they're not gonna give you one. And so we sued them through Damian with the PLF, and we lose it in Boise down here. We lose it. I knew we were gonna lose in the Ninth Circuit, and I remember Damian saying, well, there's only one place to go. And I said, what do we got to lose? What? And I just remember early on from a relative, the most dangerous person in a war is one that's not afraid to die. And we weren't afraid. It's like, no, we're not stopping. So it got accepted to the Supreme Court, and we went the first time, and you think about that, going to the Supreme Court, and I'd love to tell you guys a story because it was quite a day, but to go in there and listen to what went on, Damian only had a half an hour to plead his our case, and he gets almost done, and he wants to leave 5 minutes, and I'm watching the clock, and I knew he was gonna leave a little extra time for a rebuttal. Well, Ruth Bader Ginsburg asked him a question, and it took her a little while to ask the question, and you could see Damian trying to hurry up and answer and get out of the way. Then EPA's attorney gets up there, DOJ, and he gets up there, and this is how he starts out. He says, and this is basically what he says, I can't use all those fancy words, because, but this is just how out of touch the Sacketts are with this case. They don't even know that their fines aren't $32,500 a day, they're $75,000 a day. So up until the last Supreme Court win, our fines were $468 million. And I don't know what that is between friends, but it seems like a lot. And so I don't want to get too far into the weeds, because I'm supposed to keep this short, and that's not easy, because anybody that knows me knows I like to tell the details of the story. Brad's smiling at me because he probably wants me to tell him, but yeah, she's cutting me off. But what I really want to do is you guys, this is so important. That second win in the Supreme Court changed it forever. And right now the Corps, the EPA, they're just being very willy-nilly on it, and no one's forcing their hand. Part of it is, and I'm gonna let Damian explain all that, but what what Heather and Judy and what's gone on and what we were down here a couple weeks ago is so important for the state of Idaho. And really, I think you guys are pioneering something that's gonna fall into every state. I think it'll get everywhere. And that's ultimately what needs to happen to force their hand to abide by the Supreme Court ruling. So I'm gonna get out of the way, and Ray and Susan Cagle, and they're with Cagle Environmental, they're gonna come up here and talk.
Okay. Can you hear me in the back?
Yes.
Okay. I'm Ray Cagle. This is my wife, Susan. I'm going to speak first. The first thing I want to say is thank you. I want to thank you for attending, ladies and gentlemen. It's good to see you here. Because like Mike Sackett just mentioned, this is a very important issue. And it goes beyond the boundaries of the state of Idaho. It's very important. I mean, Idaho can be leading the charge, if you will. But there are problems, serious problems, with overreaching regulations with the Army Corps of Engineers all over the country. As a matter of fact, since their first U.S. Supreme Court case win back in 2012, the Pacific Legal Foundation, PLF, mostly through Damian Schiff, their attorney, has recommended us or directed us to help others in places as far away as Puerto Rico in the last 2 years, and we've been to North Carolina for alleged violation cases. We recently, through the PLF, ended up in Colorado. So we're going all over the nation trying to help people. And just give you a quick background, and then I'll let Susan talk. I used to be on the dark side. I used to work for the U.S. Army Corps of Engineers, and that's how I ended up in Idaho. I was transferred to Idaho back around 1992 in the Idaho Falls office. For those of you that might not know, most of you do know, that in the state of Idaho, under the Clean Water Act, Section 404 of the Clean Water Act, dealing with water streams, rivers, creeks, and wetlands, you come under the jurisdiction of the Corps District, which is headquartered in Walla Walla, Washington. So I was transferred here from the Omaha district, and before that I was transferred from Philadelphia district. So I was with the Corps of Engineers for a long time when I came here, and actually because of my position with the Corps of Engineers and my seeing how the Corps of Engineers, in association with the EPA, where they have like joint regulatory authority, ultimate authorities with the EPA under Section 404 of the Clean Water Act. But I was observing how Idahoans were not treated fairly and respectfully, even with common courtesy, by the Army Corps of Engineers, my own agency. And at one time, I decided to expose that to my supervisors. And back then, Idaho had a wonderful United States Senator named Larry Craig. Might even be in the room over here somewhere, yes. And he said, well, you know what, Ray? He said, I'm going to see what I can do back in Washington, D.C. about keeping your position and your job in Idaho Falls, because we need people like you that are not afraid to speak up truthfully in representing the Corps of Engineers and the EPA. At that time, I was not only the review officer and the appeals officer for any wetland studies, wetland jurisdictional determinations anywhere in the state of Idaho. If there was going to be some kind of controversy or if there was going to be litigation, I was the one in Walla Walla District that they would send throughout the state of Idaho to make the final decision on behalf of the United States, i.e. the Corps of Engineers and EPA, the final decision on what is waters of the United States. So I had that responsibility until the Corps wanted to get rid of me. And Senator Craig at that time, with his contacts in Washington, D.C., I think several high-ranking, or the highest-ranking general in the Army Corps of Engineers, basically dictated that you're going to keep that position and Ray Cagle in Idaho Falls. And so my position was funded again for about another 3 years. Since then, I went from the dark side I had my belly full of observing how people like the Sacketts been treated by the Corps and the EPA. So I went into private consulting. And then I dragged my wife, who just was in a different career, a PhD scientist up in Bozeman, Montana. And now the last 18 years, she's been my partner in crime, trying to protect people in the state of Idaho and all over the country from the overreaching, unfair practices by these two federal agencies. So I'll let Susan say a few words. Thank you.
Yes, I never pictured myself being fighting for wetland fairness when I was first started into college years ago. But Ray and I moved into doing more violation work not long after we got married 18 years ago, because we saw that there was a real problem. When somebody gets a violation, it's rarely something they intended or consciously knew they were going to be in trouble for doing this. And then they get a letter from the EPA, which is typically what happens, and that is a bad day. Bad day. They don't even know how bad it is yet. And it's going to be hundreds of thousands of dollars to get it resolved, even if you want to play nice and do whatever. So we started looking online at the EPA website, because they like to publish every violation that they were prosecuting. And we started trying to track down people. And that's how we ended up one of the Sackett's neighbors up in northern Idaho. They came after a man up there who had 4 acres. He bought to build his retirement cabin. He got all of his permits, building permits. He had a title search, etc. He starts building his house, and a neighbor next door didn't like it. So she called in the Corps, and pretty soon he has a criminal violation. He went to trial. We found this violation online. We talked to his attorney. He said, "Oh, thank goodness, we need somebody to come up here, and maybe it's not 4 acres of wetlands, maybe it's only 2 or 3, and that will reduce the penalties." So we went up there. We didn't find any wetlands. And when we got done with our field work, they said, "Hey, you might want to stop in and see these people down the road, the Sacketts. They've had a little issue with the EPA." And so as we walked into the office cold, and they were a little bit like, "Okay, you're who?" But we became friends. We did a delineation, and that's when we were able to tell them, "We don't think there's any wetlands here. There may be a teeny weeny little spot on one corner you might be able to make an argument for, but we don't believe there's any wetlands." So that's really the dirty little secret that Sackett 2 was about isolation of wetlands. That was all fought over property that had no wetlands. And that's the way the agencies work. And so we've been working, like Ray said, all over the country on violations. We've been to Alaska, New York, Pennsylvania, a couple of them there, lots in Iowa, and I know I'm forgetting some. But it is a fight, and we've all been given hope by what happened with the Sacketts and the Pacific Legal Foundation. And something the Pacific Legal Foundation does a lot with cases we have is sometimes they don't take them on as a full-fledged case, but they will consult with the attorneys that are involved. And that's a great way that they spread their assistance out to use that money more efficiently. And I just want to encourage you to really look up their website and make donations to it, because they are doing great work. And they do take on little people who I don't think there's any way the Sacketts could have fought as far as they did. I don't think it wasn't costly for them, even with the help of the Pacific Legal Foundation. But they are a great, great organization. And it's my privilege to introduce Damian, who has really led the fight in the Clean Water Act legislation. So thank you, Damian.
Good afternoon, everyone, and it is a pleasure to be here. I want to thank Representative Scott and Representative Boyle and all of the elected representatives here for coming. It's an incredibly important issue. It's been an honor for me to have represented Michael and Chantell Sackett since 2008. Now, In some respects, the Sackett story is a victory. In some respects, it's kind of an indictment of our system. It's a victory in that the Sacketts went to the Supreme Court twice, and unanimously twice had the EPA and the Corps rebuked for their misinterpretation of the Clean Water Act. That's great. The indictment, though, is should citizens have to spend almost 2 decades of their life just to be able to build a single-family home in a residential subdivision, already platted, already ready to go for development? They have neighbors who've had houses for decades. That seems to be a problem, and I hope that some of the litigation successes that the Sacketts have been instrumental in creating with the help of PLF's representation will maybe end some of that so other property owners won't have that problem. In just a few minutes, I want to give a little background more about what the Sackett decisions really mean, because there are 2 decisions, both of which I think have had a big impact on how federal administrative agencies operate, in particular over the Clean Water Act. So the Clean Water Act was enacted in the early 70s. It was enacted as a water quality statute. The idea was we don't want our rivers catching on fire anymore. That seems fine. Everybody's in favor of that. But pretty quickly, EPA and the Corps totally mistook the mandate. Congress said, yeah, make sure that we don't have polluted drinking water. But they took it as, let's now become land use administrators. Let's now assume that when the statute says waters of the United States, that also means dry land that we can then say is a wetland, that we can then say is sufficiently connected to some downstream water, that we can then say the whole thing is regulable and you need a permit in order to develop it. And when we're talking about permits, we're not talking about just getting some building permit that costs very little time or effort. We're talking about Federal Clean Water Act 404 permits, which can cost hundreds of thousands of dollars, if not millions of dollars, depending upon the size of your project. So that's where the agencies went wrong. Now, what have the courts been doing since the agencies have been acting wrong? Well, to their credit, a lot of the courts have been saying you've been going too far. And the Sackett's first Supreme Court win in 2012 was part of that effort, where the EPA, as Mike had mentioned, had issued the Sackett's a compliance order under the statute. The statute says that if the EPA thinks you're violating the Clean Water Act, it can issue an order, and the order can direct you to restore your property, it can direct you not to use your property, and as Mike mentioned, if you violate that order, you can be liable for tens of thousands of dollars per day in civil penalties. So it's a pretty significant thing. Well, remarkably, EPA had taken the position that we can issue these orders, you have to obey them, otherwise you'll be liable, but you can't sue us over them. We don't consider this to be a final decision. We haven't finished our enforcement process. This is just one step in this iterative process that the agencies will have with the landowner, so therefore you can actually seek to vindicate your rights in federal court. That idea had been accepted by a lot of lower federal courts before the Supreme Court in 2012 took up the Sackett's case and said, lower courts are wrong, EPA is wrong, that yes, you have the right to sue immediately. So that's a big win for property owners just to get into the courthouse door. But for the Sacketts, that was just the start of their saga. That was 2012. What they won there was simply the right to plead their case, not that they necessarily would win. So back in the district court, we argued how on the merits, this is a single-family residential lot. It's not a water of the United States. Even if there are wetlands on it, and as Susie Cagle mentioned, there aren't, but even if you assume that there are wetlands, you can't treat those as waters. You've got the property that's separated by another road from a drainage ditch. On the other side of the property, it's separated from Priest Lake by another row of developed houses. So there's no way that you could say that anything on this property can qualify as a water. Nevertheless, unfortunately, the lower courts ruled against the Sacketts using what was then known as the significant nexus test. This was a test for EPA authority developed from a concurring opinion by Justice Kennedy in an earlier Supreme Court Clean Water Act case. And as the title suggests, significant nexus, it was kind of a vague test that basically allowed EPA and the Corps to regulate whenever they wanted to. Now, not only was that violating individual property rights, but it was also a threat to federalism. Because now you have federal agencies who are saying, oh no, we don't care what Idaho thinks, we don't care what Bonner County thinks, we're saying you can't build there. And it's essentially a federal veto on ordinary land use activity, not just home building, but of course agriculture and other land use. So we asked the Supreme Court to take up the Sackett's case again to say, hey, this significant nexus test is getting the statute all wrong. It's threatening our federal structure, it's threatening individual liberty and private property rights. We think, Supreme Court, it's time for you to take up the issue again. And they did, and in 2023 they issued a ruling which, although was not unanimous in all respects, it was unanimous. Every single justice of the Supreme Court, including Justices Kagan, Sotomayor, and Jackson, all rejected EPA's significant nexus test. They all agreed that it had nothing to do with the statute or congressional intent. So that actually, I think, was another big vindication for the Sacketts. But what the court also said in a majority opinion written by Justice Alito is that the scope of the agency's authority is much narrower than they've been thinking. That essentially when the statute says waters in the United States, that more or less means waters, meaning physical features. You go out and say, yes, that's a stream, that's a lake, that's a pond, and that these things have water in them for most of the year, and that they're connected to actually navigable waters. And the court also said, we acknowledge that yes, some wetlands can be regulated, but we think that the number of wetlands is a lot less, again, than what EPA and the court traditionally have said. That more or less you can only regulate wetlands under the Clean Water Act if they're so physically connected to a real water that you can't tell the two apart. That you've got a constant flow of water that essentially it would be arbitrary to sort of divide the two. But where you don't have that line drawing problem, the wetland can be regulated. So that meant the Sacketts finally, after 16 years of fighting the federal government, finally had the okay to say, you were right all along. We shouldn't have said you couldn't use your property. We don't have the authority for your property. What does that mean for the rest of the country? Well, that's what we're trying to find out now. Meaning that, perhaps not surprisingly, the Biden administration took a very narrow view of what Sackett meant and tried to codify that view in a federal regulation. That regulation, I think, really seriously misconstrues what the Supreme Court meant, and not surprisingly, that regulation has been challenged in a lot of cases. Now, the new administration has said correctly, we don't like it either, and we're going to try and fix it, and the new administration has a new rule that's still pending that tries to make the agency's practice a little more consistent, or I should say a lot more consistent with the Sackett decision itself. That rule is still pending, but I expect it will probably be finalized sometime in the next couple of months, and that'll be another big step forward. The final step forward, though, is something that I think our next speakers would be very keen to talk about, and that is, despite 2 Supreme Court rebukes of EPA and the Corps, despite the Supreme Court saying clearly the statute is much narrower than you think, and despite even the current administration at the political level saying we need to change what we've been doing, there still seems to be resistance at the lower levels of the Corps and EPA. Resistance in the sense that they either don't understand or perhaps they're deliberately misconstruing Sackett in order to maintain a business as usual approach. This is something that PLF has noticed in several cases for property owners who have come to us after Sackett, where we've had to represent them in the administrative process to correct what the local court districts have done. But I'd like to invite up the Avamore folks to talk about an instance right here in Idaho where this same problem is still lingering. Thank you.
Good afternoon, Brad Famler, General Manager and Partner at Avamore, and Damian Schiff, thank you so much. And the Sacketts and the Kegels, over the last few years, we've learned a lot. The number one thing that I always thought was, and I've said this to pretty much everybody, is when you deal with the federal government or a government agency, you always think that their number one job is to follow the U.S. law. If the Supreme Court comes out and says something, this is what you would expect. They're going to follow the Supreme Court law. And what we found is that is not the case. Truly what's been happening is that they have their own agendas on how they want to process whatever they want with waters of the U.S., or they don't want you to develop here, or there's other issues that pop up over there. And what that does, at least for us, is over the last 4 years, we've been fighting a battle about a stockwater pond that the family dug in 1981. Highway 55 got relocated to this location. It cut the water off of their cattle. They'd owned the land since 1916. They've been raising sheep and cattle on this property. It was over 50,000 acres at the time. And they, in 2008, they decided that they wanted to develop, and we were kind of going down that path. But meanwhile, there was a stockwater pond that was on the property that was next to Highway 55 that collects water from a drainage area. We're 15 miles from the Boise River, which is the only navigable river in our general area. And we did this environmental study. Our environmental guy says, no water to the US anywhere in here. It's all uplands, sagebrush, bitterbrush. We submitted it to the Corps in 22, and I actually walked with him when he was doing his report to make sure. My dog was in most of the pictures of the report. And for a year we heard nothing. We kept reaching out to the Corps, didn't hear anything. And then about 16, 18 months later, we get something back saying they don't do AJDs anymore, which is determinations if it's waters or not. The only thing that they do is they do 404 permits. They say you need to submit a 404 permit for this one stock water pond. And I'm gonna back up one step so that you can understand kind of the time frame that I have experienced over my career. In 2000, I started as a construction manager for a local contractor. In 2004, I went and moved to a position where I worked for an engineering firm. And at that engineering firm, I was in charge of land developments throughout the valley. I worked there until 2009. But in 2004, I started working with a gentleman at the Corps named Greg Martinez. And he had been in the valley for a really long time. Greg went and taught me right away the things that you do in order to determine what's waters of the US or not is hire an environmental group, have them do a study, submit it to me for an AJD, and then we'll review it, we'll get back to you, and then we'll determine if you need a 404 or if you need if it's non-jurisdictional. And this worked extremely well for years. Greg retired in 2014, 15, somewhere in there. And Avamore, we are 23,000 acres, 35 square miles. Every year we have another project that we're bringing to them, and we're constantly going through that process of getting an environmental study done, having the Corps come out and review it. We've done multiple 404 permits on little things that popped up. But that was the process, and I guess what I'm trying to explain is there was a simple process. In 2022, that completely changed. And what I mean by that is we heard zero from the Corps. They wouldn't respond to emails, calls, nothing. And so it just kind of left us in limbo. Meanwhile, ITD is through our local area, spent over $10 million on an underpass and widening Highway 55 for safety corridor improvements, which is extremely important. You know, when you add 10,000 homes to an area and you don't want to go at grade or at the same level as a car doing over 60 miles an hour coming down Highway 55. And so that was one of the things that was put in place was a $10.5 million underpass. Adjacent to that underpass is a stockwater pond. Meanwhile, we are almost completed with the underpass with ITD, and we can't put in our local road to go underneath this underpass because we hadn't got one, a concurrence that it wasn't waters of the US, or two, a permit. We received a letter from the Corps on their 90th day, which they're required to respond to you, when we did file a 404 permit, saying you have possible waters of the US violations. Possible, and that's really important for what I'm about ready to say. All right, so then they say, we want to come out and have an investigation, but we don't want to do it right now because it's January. We want to wait until April, and we're going to come out in April with the EPA and review your site. So they did, they came out. About another 90 days later, we received another letter from the Corps asking the EPA to take over all jurisdiction on the site because there's possible waters of the US violations that have taken place on our property. Meanwhile, Avamore, all we did was put silk fence around this stockwater pond. ITD was building an underpass that was directly adjacent and moving dirt and things around. And then we've had, at this inspection, one of the first things that the EPA does for you is and I know I probably need to speed this up, I apologize. The EPA does this, is they'll give you your badge, and they'll tell you that if they find anything out here, that you can be federally prosecuted with a felony if you don't work with them. and just let that settle in for a second. Here we've done everything we thought we were doing right, and I could go to federal prison because of it, all right? Which is a problem, because we haven't done any work yet. Meanwhile, here we are, 2026. Last Friday, I received from the EPA out of the blue, they aren't gonna prosecute, or they're not gonna move forward. They're turning everything back over to Army Corps. And that they still reserve the rights to do all these things. But I guess where I was trying to go, and I know that I've gotta turn this over, is that it's still happening today. We're 15 miles from the Boise River. This area is dry for 10, 11 months out of the year. It was a stockwater pond that was actually put in by the family for their cows. And we have $2 million worth of work that we've had to do right there in 4 years. And we get zero out of it. And the reason why I said potentially Waters of the US is that they've never actually allowed us to go to court because they haven't made a determination after 4 years. And so that's where we kind of are right now, and we just really appreciate all of the representatives that have come together today and allowed us to speak up here on this really, really serious issue. I know that I'm a developer, but ranchers, farmers, irrigators, regular citizens of the state of Idaho, this is a big deal. Because before, you didn't have an irrigation canal, couldn't be classified by the Army Corps. They currently are doing that to a number of different people in this valley and in the state. And I think it's extremely important that at least the legislature, that you guys have been able to step up and get this joint memorial moving. And with that, thank you very much for allowing me to speak.
Well, we wanted to make sure there was some time for the lawmakers, and if anyone else has some questions for Damian, since we have like the nation's foremost expert on this issue in the room. And so I want to maintain that time. Before we get to that Q&A though, I really want to thank the Idaho Freedom Caucus, Representative Heather Scott, Representative Judy Boyle, for spearheading this issue. This is a complex issue. This is not one of those issues you're gonna see on like primetime TV, and yet it really could actually wreck this entire state's economy. It is already having a dramatic effect and has done real damage to Idahoans in the state. And so it's one of those issues that we do need to raise awareness of. And so Representative Scott and Representative Boyle have never shied away from a fight. And so I'd like to invite them up to talk about House Joint Memorial 13 and the work being done there to invite our congressional delegation to take this matter more seriously, and also to bring more people being affected by it to the table. And so, you know, get in touch with us. If this is an issue you've dealt with in your life, make contact with us. We need to band together. That's the only way you're gonna beat the feds, for crying out loud. There's no bigger, badder wolf out there. So Representative Boyle, Representative Scott, you wanna come on up? Thank you. Real champions.
Thank you guys for attending, and just to touch on what Brad said just a bit. The Freedom Caucus, we work with all kinds of conservatives in this state. We are very concerned about state sovereignty. That is a big issue of ours. It's part of our agenda, and bloated bureaucracies, and that is what we see here. We want to save time for questions, so I'm going to turn it over to Representative Boyle. Representative Boyle runs the Federalism Committee, which meets, it's an inter-committee, she meets all summer, and so she took the lead on this, and I would like her to just explain it and probably mention our other sovereignty bill.
Well, I am super excited and honored to meet these wonderful people and meet Damian finally. I've talked to him once on the phone, but I've followed PLF for many, many years. I learned about how horrible the federal government treats people as a little kid from my grandfather, who at one point, long before I was born, had a grazing permit. And not long after the Taylor Grazing Act in the 30s, the ranger began to boss him around and tell him that he had to put salt down at the creek instead of up in the rocks where he'd always put it. And he informed the ranger that his family had put salt up in that spot since 1886, and he wasn't going to be bossed around and told to put it in the creek. So he went home and told my grandmother, we're getting rid of the permit, we're buying private land, and none of my ancestors will ever have anything to do with the federal government again. So I learned how to deal with them at a young age. I'm really happy that we were able to work with Ed to do this joint memorial. So here in our state, we do joint memorials to the federal government, to our delegation, to say, we have an issue here in Idaho and we want you to pay attention and fix it. So when we had our federalism committee, one of them this year, I had our attorney general and his natural resource chief come and give us a 101 on the Sackett case, which I had followed from the very beginning. These guys are my heroes. And so then Ed brought this language and we said, well, we'll just run this. Now I used to work for a congressman who was there when Senator Craig was there. And if she or the senator would receive something like this from a state legislature saying, fix this problem, they were on it instantly. This didn't go by the wayside. They really did constituent services. And that's what I expect of our current delegation. But apparently we have to really push to get them to do something, unfortunately. So this is asking the White House, the EPA, and the Corps to follow the law and to follow the decision. And we're asking our delegation to bring forward a bill to put this decision into law. It's not that hard to do. You know, we've done it many times before, and so this is what we expect. And hopefully we're gonna get Alamo mess straightened out as well, along with all the other people across the United States. There's no sense in the federal government doing this. Anyway, our other bill, sovereignty bill.
Yeah, just touch on it.
So this was a fun one that a gentleman brought to Representative Scott and I. And it just lays out the basics of federalism. Honestly, says the Constitution has specific power for the state and for the feds. Everybody needs to stay in their own lane, and we really mean it. So we've passed that through the House, and it's over here in the Senate waiting a hearing.
I'm just gonna add one more thing. If you're watching online or you're here today and you have issues, little issues, and you just don't know who to call your legislators, call your state legislators, your senators, or your representatives. We can help you get in touch with the right people to navigate the system to push back on this, because we have a little bit more time with the federal delegation right now, and we gotta do everything we can to secure Idaho. So thanks for attending today, and we'll
Q&A.
We'll do Q&A for, that would be great.
Yeah.
I think we don't need to be up here for that.
Oh, well, really, thank you. I know particularly for some of the lawmakers, I know this issue might be a little bit new, and we kind of started in really at the depth of it that's maybe a little more convoluted, but do you guys have any questions while we have yes, Damian, do you want to come up? You got a question?
A question for me, sure.
Yeah, I would answer, but you should ignore what I say.
I got a question. So if Congress was providing the right amount of oversight for the Clean Water Act over the EPA and the Army Corps of Engineers, what would that look like? I mean, would we have staff from the Congressman's office out in the field, or how do you see that happen?
I think there are a couple of things. One is,
question for the
right, thank you for reminding me too. The question is if we're encouraging the federal delegation to increase oversight over EPA and the Corps, how is that done? Well, at one level, it's a funding issue. So for example, and Ray can correct me if I'm wrong, but oftentimes when it comes to the funding of core districts, I think a lot of it is based upon how many permits you're issuing. So if you find that you have more jurisdiction more frequently, that means there will be more permit applications, which means there's going to be more need for more funds. So I think maybe decoupling funding from how many times you find things to regulate would be one thing. The other thing, and this is a more general problem, not limited to EPA and the Corps, but it's something the Trump administration floated in its first term, and that is changing the federal civil service system so that that more agency officials who today have protection under the civil service system would lose that because they are actually operating politically sensitive positions. And this is something that is one of the entrenchment problems that we've seen with the Clean Water Act and other controversial issues, is that you have tenure protected civil servants, and that's, in theory, that's fine, but they also then wield a lot of discretionary authority. And that's where you get into trouble, is that if you have officials who are wielding a lot of policy-making authority, they need to be accountable, otherwise the elections don't really have any consequences. So that in particular has been a problem with EPA and the Corps, where a lot of the people who are making these decisions that I think are inconsistent with Sackett, they're in that level where they're not politically appointed, they're career civil servants, but under current system, it's very hard to say that, well, you can be removed just because of the decision you've made that we think is inconsistent with Sackett. So those are two things, the funding and the civil service protection.
Thanks.
Is there anyone here that's been affected by this issue? Do you have any questions for Damian? All right.
Oh, sure, okay. And back?
Yeah, quick comment. So I had the pleasure to go to Hillsdale College for my graduate education. I just want to let you guys know that one of the core classes we have to take is called Modern American Regime, in which we study the administrative state and how it erodes our constitutional rights, the rule of law, and our constitutional order. And actually, Sackett 1 is one of the core cases that we study at Hillsdale. And, you know, my academic circle is pretty niche, but I just want to let you know that the work that you guys have done to move, claw back power from the administrative state is reverberating across this country, and it goes beyond, your individual case. And there's an entire generation of young people such as myself who've learned your case, or getting excited about administrative law, which is not really something you usually get excited about. And so I just wanted to thank you guys for your courage. It's really, truly amazing story. Thank you.
Yes, sir.
I have a question. I was thankful that you mentioned the fact that, like, on the ground, some of the stuff that's happening in administration is not making it to the ground. Because I don't know how many people are aware that even though these edicts have went out and they're supposed to be behaving different, on the ground they are not. So we still have people all over Idaho suffering. We had a case where the Corps of Engineers wouldn't even opening up a camping area along a river that they were in charge with. And we had the opportunity to get the information into DC, and they put out the order to open it, and they did not do it. By the end of summer, it wasn't done. So even though the administration is doing better, how do we get that to that ground game where these people who are entrenched and been employed for 20, 30 years and did not make the decision that this gentleman made, that this isn't right, and they just keep on that path?
So the question is how do you deal with the bureaucrats who are entrenched, who are not responsive to changes in administration or changes in Supreme Court case law? I think one thing that'll help when it comes to the Clean Water Act is the finalization of the administration's proposed rule, because I think some of the mischief that's been going on at the lower levels is been incentivized by the confusion about, well, what should the rule be after Sackett, because our regulations have been challenged, we don't have enough guidance. So someone could say, well, I just don't know what to do, and so that's why I'm not going to do anything. That plea of ignorance won't be credible anymore once a new regulation is finalized. Now, even then, you're still going to have some issues with trickling down and some recalcitrance and all that, but I think a lot of it is because this plea of ignorance has been effective in the first year or so of the second administration, and I'm hoping that when the WOTUS rule is finalized, which will probably be sometime, I would hope the next few months, that some of that will stop. Yes, right. Yes, sir.
So yeah, I don't know, I wanna ask if there's anybody here from the Idaho Department of Water Resources? Anybody? So, whenever you're coming in to Idaho and you're gonna purchase a piece of property, you do your due diligence, right? So, we come in and we find out, yeah, we have water rights to this piece of property. And it dates back into the 1800s. And we have the grandfather water rights to here, right? So I go to the Department of Water Resources because I don't necessarily want to trust what the realtors are telling us. We want to find out what the truth is. So we have the water rights that are stated, right? So like Mr. Sackett, I asked, well, I want to put some stock ponds in, right? So what are my regulations in order to put in stock ponds? And they told me as long as I have a spring that is generated on our property and it does not leave our property and go to the neighbor, that I can do with whatever that I want to with that spring. I can put in stock tanks or whatever because that water doesn't have the hydraulic ability to go downstream. So that's the same thing that you're talking about. I imagine a wetlands is a spring, correct?
Yeah.
So, and if it doesn't travel to the neighbor, then I can do with it what I want. I don't have $4.5 million to go spend fighting this deal. But I go to my local water agency and ask them what I can do. They tell me what I can do. Do they trump the federal EPA? You're talking like now, they can come in, they can ramshot what my local water district has told me that I can do with my water, and now I can't do it. Or they can come in and they can control situations that I am doing with my water. Are you telling me that's what's going on?
Yes, yeah, so just to summarize, again, the question is, you have spring essentially on your property, it doesn't connect anywhere else, you would like to create a stock pond. Does the fact that it's essentially isolated mean that you only have to get your state or local authority approval? And the answer is, well, you would say yes, except the Sackett's case and the efforts of EPA and the Corps to assert their authority under the Clean Water Act. Even assuming, again, you know, as Ray and Susan mentioned, there aren't any wetlands on their property, in fact, anyway. But if you assume even that there are, those wetlands are, as you would describe, isolated, meaning that they're not federally regulable. But even when you have a state or local agency saying that, does not bind EPA and the Corps from taking a different view. And because they have a lot of enforcement authority under the Clean Water Act, they have a lot of leverage. And people who might otherwise, like yourself, have a good claim against them might not want to risk advocating for that claim because of all the time and expense required to vindicate the claim.
Well, I don't want to take all the oxygen out of the room. I have a lot of questions.
Well, let's take, we have one,
Yeah.
we have one over
question,
here,
sure.
and then, after the event, maybe we should connect with you
Yeah.
and chat. Dave, you had a question first.
Thank you, Ed. Thank you, everybody, for being here. I'm a second-generation land developer, full-time since the mid-90s. And going back to the George W. Bush administration, I was actually local representative for the state of Idaho at the EPA's office for the National Home Builders on behalf of stormwater issues. So I have a little understanding of what this fight is. And I specifically asked the question, how did you determine your fees? And their answer was, we think it's set just high enough to not put you out of business, but to cause enough pain that you'll change your attitude. And I said in response, you don't know what it takes to be a builder in Idaho. It takes a pickup truck and a dog, and you call yourself a builder. And that's still pretty much the case today. My questions to you are this. First of all, to the Cables, thank you for all your work. I've worked with other consultants. I've never met you before. There's a significant shortage of resources. So I don't know if you've, we can talk offline, but just for everyone's benefit here, it'd be nice to know if there's a broader resource of common sense solutions to to identifying waters of the U.S., and I'd be happy to have that conversation later. Secondly, my question to you is this. You mentioned the word mischief on behalf of administrations, and I've seen that over the years. That's why I gave you my background. My question to you is, do you really think that after a few months from now, when a final order is issued with this current administration, that we'll be done with the mischief of how you determine waters of the U.S.? Or when we have a new administration that might be from the other side of the aisle, we may see more mischief?
Yeah, the question is, will the bureaucratic mischief that has been happening even since the most recent SAC decision persist, even with a new rule issued by the Trump administration? And the short and lamentable answer is the mischief will continue. Now, will it be at the same? No, I don't think so, because part of the problem we've had over the last 20 years is that administrative agencies have had a lot of leeway in how they can interpret the statutes, and that's caused big swings in things like the Clean Water Act practice based upon who is in the White House. That is really not as possible now as it used to be, both because of the Sackett decision that narrows the scope of agency discretion, and also because of the Supreme Court's separate decision to get rid of what was called Chevron deference, where agencies could interpret ambiguous statutes and the courts would sort of reflexively accept their interpretation. The combination of those two things, I think, means that, sure, there's a scope of mischief possible, but that scope is a lot narrower than it used to be. And so I hope that regardless of what happens in future elections, that the degree of abuse of private property and of our federal structure that has happened in the Clean Water Act will be a lot less. At least that's my hope. That's my sincere hope.
Yeah. Damian's going to stick around for a little bit before we have to testify at 1:30 on a bill. But feel free, come chat with them and come meet the Sacketts. You never have to wash your hands again after you shake their hands, right? But it is 1 o'clock. I know a lot of our legislators have committees and things to get to. So I want to thank you guys for coming in. Thank you.